and it has to do with the Fifth Amendment to our option to purchase and lease property from Weyco. And just to be clear, so that we understand that, I've asked Mr. Bishop if he would present this again. It's very similar to the same things that we've done in the past, and would you do that for us, please?
Thank you, Mr. President. The item on your consent calendar tonight is the Weyco and Jordan Cove land option agreements. And for some background, let me recap what the original deal was. The port entered into an option agreement with Weyco in 2006 and also with Jordan Cove. The original option was for 2 years in length, with Jordan Cove possessing a 6-month extension option, which it did exercise at that time. The option price was indeed the purchase price for the property of $25 million. Weyco had to agree to repay the purchase price if the option was canceled, and they did indeed return the $25 million. The port had 2 years to perform due diligence and did do so. The agreement did require the port to indemnify Weyco from any future cleanups in the event that such a thing arose. The port was to purchase insurance to pay for a cleanup in the event that it was necessary, but the port was also authorized to negotiate a PPA with the state of Oregon, which is a prospective purchasers agreement. At that time, the port borrowed $10 million from a local bank, and the port borrowed $15 million from the state of Oregon. The agreement was drafted by at least 10 attorneys, including participation by the Oregon Attorney General's office. Who paid for it? It was all paid for by Jordan Cove. The port entered into an option agreement with Jordan Cove Energy Partners. The option had 3 sections: an option to buy in fee 147 acres, and an option to lease a berth area, and a non-binding exhibit to serve as a guide for future negotiations for different business relationships between the entities. The property that Jordan Cove had the option on to buy in fee is indicated in this drawing by the purple or blue shaded area. The berth area, which was provided as a lease in the document, is designated by this orange or yellow area in this particular drawing. There were indeed subsequent amendments. This is, in fact, the Fifth Amendment. Previous amendments extended the term of the agreement. The last amendment refunded the prepaid purchase price, and this amendment further reduces obligations of the parties. Much has been written and much has been said, and as it occurred to me, I wanted to make sure that I was very clear about this. What is an option? This is an option. A real estate option gives you control of a piece of real estate without buying it. By having options on real estate, you have the exclusive right to either buy that property or not to buy it. Tonight's action is not to acquire the property, nor have any of the previous actions on this option been to actually acquire the property. It's been to execute an option agreement. Again, this is an option agreement. This is an option agreement, not a purchase. It simply states what rights the parties have towards a potential purchase should one occur. The original option allowed for the completion of a Phase 1 environmental review for the purpose of determining whether or not the property would be eligible for a prospective purchaser's agreement. A prospective purchaser's agreement basically absolves the property owner of any future liability for cleanup after having entered into it with the state. The purpose of the Phase 1 was to determine whether or not the property would be eligible for a PPA. The consultant who conducted the work indicated that it would be eligible. Further, this is not a project contract. There is no action contemplated by this agreement. Therefore, anything to do with a permit, any particular type of regulation on the use of the property is not relevant to the agreement. It is an option agreement. So what has changed in the current set of agreements? The new agreement contemplates the ability to purchase less than the whole of the portfolio while preserving the right to purchase the whole. This is a remarkable change from the original agreement, where the port was required to acquire the entire portfolio. It allows for also a greater accumulation of equity from the option payments being made on the contract. It also increases the cost of the property to Jordan Cove. We also contemplate yet more changes to the agreement that will take place in the future between now and the end of the agreement. The parties expect to make more changes in the agreement in the future. These changes are primarily intended to give the developer and the port even more flexibility with the property and the use of the property. Anticipated changes will be to remove use restrictions on the property. This allows the developer to purchase the property for some use other than an LNG import terminal. In essence, provides the developer an exit strategy. Elements of the new Weyerhaeuser option are as follows. The option will be extended through June 30th, 2011. Payment for this extension will remain at $450,000 per quarter, payable before January the 10th and before April the 10th. Jordan Cove has already underwritten those payments. If the port triggers the option on the whole property or the Ingram Yard lagoons as described below, the $900,000 paid in option fees would be applied to the purchase price. If the port triggers the option on the whole property or the Ingram Yard lagoons, the previous $150,000 quarterly payments from previous options would also apply towards the purchase price. If the port does not trigger the option before its expiration on June 30th, 2011, the $900,000 in payments made in 2011 shall be deemed earned by the seller. In other words, Weyerhaeuser gets to keep those payments. Again, let me reiterate, those were not made by the port. They were made by Jordan Cove through pass-through payments. The option can be triggered at any time, but it cannot be terminated by the port before the expiration. Naturally, the same condition applies to Jordan Cove, and in this particular case, since it's prepaid, it's not particularly an issue. The property referenced in the option will be broken into 5 parcels. Let's talk about those 5 parcels. This is a poor map, but I will do my best to try to explain it. The property that's being described as the Ingram Yard is the property that consists of both the original Jordan Cove fee interest parcel that was in the original option, plus the berth area. For the purposes of the Weyerhaeuser agreement, it is one piece of property. For the purposes of the Jordan Cove agreement, it is 2 pieces of property. It is the fee interest piece, and it is the lease berth area. For the transaction with Weyerhaeuser, again, it is one piece of property. This is the Ingram Yard. The second piece of property is what we've labeled the lagoon, which is the large parcel of property on the North Spit that was used for the wastewater treatment facility from the original mill operation on the North Spit that Weyerhaeuser operated, and before that, Menasha. Also included in that is the oyster bed leasehold fee interest that Weyerhaeuser owns in and around the Trans-Pacific viaduct. The next piece of property is what's referred to as the mill site, and that is the original site where the Weyerhaeuser paper mill was. And then the other site is the property that we're referring to as the Henderson parcel, which is the remaining balance of all the unidentified property. The port will be responsible for legally partitioning these parcels before June 30th, 2011. That's basically an adjustment of tax lot numbers and is generally considered to be an administrative function. The port has the ability to buy the whole property for $25 million or the Ingram Yard lagoons for $14 million by triggering an option specific to those parcels before June 30th, 2011. Again, either of those to be underwritten by Jordan Cove. Closing would occur within 30 days following the trigger of the option. And assuming the port triggers the option on the Ingram Yard lagoon, the port will pay $8 million at closing and receipt of deed of trust or other conveyance documents. The port will have full access and ownership of the property as of closing, but a note or other such document will be issued for $6 million to be paid in full by the port on or before January 30th, 2012. A warranty deed, which is also a new element. Before we were talking about a bargain and sale deed. Warranty deed would be issued by Weyerhaeuser for the property, and the port in turn would then sell the property to Jordan Cove for similar terms. If an option on the Ingram Yard and lagoons is triggered, the port automatically gets a 12-month extension of the option for a fee of $200,000 per quarter. That too will be assumed financial responsibility of Jordan Cove. Again, this extension cannot be terminated before the 4 quarterly payments have been made, and therefore Jordan Cove will be required to prepay that. Weyerhaeuser, being privy to other development plans that the port is engaged with, has reserved some rights under the agreement. The property originally had a requirement that the port would have to pay for undevelopable land if it became developable. That will be removed from the agreement. There is also going to be included a new provision that the seller will receive half of any compensation related to electrical production, related to electrical production wind turbines on the property will be added to the agreement. Seller's right to purchase 20 acres will either be eliminated or made more flexible and favorable to the port. The required environmental policy will be restricted to only the mill site in the event that the mill site itself is purchased. Here are some basic facts. The port has yet to use one single tax dollar in support of this option or the previous versions. In fact, we've received a net profit. Jordan Cove ordered a new appraisal on the Ingram Yard, which resulted in a higher price to Jordan Cove, up from $10 million for their fee interest to $14 million. In the original agreement, in the latest agreement, the port receives the lagoons for free should Jordan Cove exercise the Ingram Yard option, thus preserving efforts to construct a new wastewater treatment facility using wetland technology and furthering utility of the site for migratory fowl. The increased price of the Ingram Yard parcel to Jordan Cove reduces the cost of the remaining property by $4 million. Again, the port is not obligated to buy the remaining parcels, but is obligated to pay the option fee to Weyerhaeuser for up to 1 year if it later decides to agree on an additional option. That decision would be appearing on the agenda of the Commission approximately May of 2010. The port
Must be 11.
is 11? My
Yeah,
apologies.
that's okay.
Decision was not made in May of 2010. Just to set the record straight, it would be 2011 for clarity.
Thank you. Yeah.
The port may enter into an option agreement with other parties for any or all of the property any time during the course of this option. There is no prohibition on that. The port also has the ability to assign the agreement to Jordan Cove or another party and relinquish all local control to a private party. This would have no bearing on whether or not the LNG project continues, rather would simply reduce the benefit of the project to the public. The port does not own the property and has no control over the public's access to the property. I'd like to repeat that. We do not own the property. We have no control over it other than to what is stipulated in the agreement, and that's a restriction on the ability of Weyerhaeuser to sell it to somebody else. The port does not bear any operational expense for the property unless it chooses to market the property for other uses, and then it would be limited to those marketing expenses. We do not pay the security on the site. We do not pay any taxes. We do not pay for the water that's being used in the facility. We do not pay any of the utility bills. There is no operational expense to the port. Current version of the option agreement with Weyerhaeuser and the contemplated future agreements provide the least amount of risk to date of any of the previous agreements. The current version of the option agreement with Weyerhaeuser and the contemplated future agreements provide the most amount of flexibility to the developer to use the property for any lawful use. Here are some quick facts. Had the facility been authorized after only 3 years of permitting, it would likely be under construction as of today. That would have meant 600-plus construction jobs lasting over 3 years through the height of the current recession, bringing millions of outside dollars to our local merchants and a great number of indirect jobs. The Coos County Sheriff's Office would be hiring a substantial number of new deputies rather than facing layoffs in addition to the hiring of new firefighters. $2.5 billion of private stimulus funds would have been streamlining into Oregon. Instead, the project has become a modern John Dice and John Dice. In conclusion, extension of the agreement has become routine and ordinary and qualifies for the consent calendar, Mr. President. This is the 5th extension of the original agreement, and as a result has been discussed and considered multiple times before. It creates no new, nor does it make any existing obligation on the part of the port or the public to extend the agreement or owners. Staff requests ratification of previously authorized and executed agreements with Weyerhaeuser and acceptance of the extension of the Jordan Cove option agreement. Thank you, Mr. President.
Thank you, Mr. Bishop. Have the commissioners reviewed the consent agenda? If so, I would entertain a motion.
I will move adoption of the consent agenda.
Second.
It's moved and second. Is there any discussion?
Mr. Bishop, thank you. That was very clarifying. I appreciate it.